We submitted a plea form. This will be a plea for misdemeanor use with no objection to 7411.
That's the court's understanding of the agreement.
Right out of the gate, Judge Simpson is basically warning everybody watching that this courtroom is about to become pure chaos. And honestly, he wasn't exaggerating. What makes these hearings so fascinating is that none of these defendants walk in calm, collected, or prepared emotionally. Every single case already has tension baked into it before the judge even starts speaking. You've got guilty pleas, missed court appearances, financial problems, emotional outbursts, and people trying to explain decisions that clearly spiraled out of control long before they stepped into court. And notice the energy here. Judge Simpson sounds calm, but there's already that subtle, "I've heard every excuse possible" tone building underneath the surface. That matters because this courtroom isn't just about punishment. It's about accountability colliding with emotion in real time. And trust me, some of these defendants are about to learn the hard way that sympathy and legal responsibility are not the same thing.
Is that a correct?
Correct, Your Honor. Thank you.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
State your name.
My name is Portia Ellich.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes.
Ma'am, I also have to apprise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes.
Still wish to plead guilty?
Yes.
And did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Counsel, have I complied with the court rule?
Your Honor.
People are saying,
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
7th at 10 a.m. for Judge Washington.
March 7th, 2024. At 9 a.m.
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor. And may I address our bond, please?
may counsel approach.
Yes.
I have children. I got children.
I'm sorry.
February 15th.
I've been in the hospital. I've been in all kind of stuff. I was incarcerated in another jail. I was in Wayne County Jail. That's why I didn't come back the first time. That's where that one got.
Okay, and the court's question was that there was a warrant that was issued for the defendant's failure to, she had a PR initially on this case. She didn't appear in April of 2023. She's not arraigned again by us until February of 2024.
This is where the situation starts turning from a routine plea hearing into a credibility problem. The court is no longer focused only on the cocaine charge. Now the judge is looking at reliability, accountability, and whether this defendant can actually follow court orders. Missing court for nearly a year is a massive issue, especially when the defendant originally had a personal recognizance bond. That means the court trusted her enough to let her remain free without posting money. So when Judge Simpson starts asking where she's been all this time, he's testing the consistency of the story. And honestly, you can feel the judge getting less patient as the explanation unfolds. Hospital visits, jail time, COVID, car accidents, whether true or not, the court wants documentation and responsibility, not confusion. And here's the bigger problem. Once a judge thinks someone ignored the system instead of cooperating with it, bond reductions become incredibly difficult. Question for you guys. Do you think the defendant genuinely forgot about the case? Or was the judge right not to buy that explanation?
And my question was, where was she? And then I'm going to have a follow-up question.
Okay. Yes, Your Honor. So in April, there is notes that she contacted our office that she had COVID and wasn't able to appear. It looks like that's the date that the warrant was issued. It indicates to me that she was in the hospital some time and she was in a car accident and also in custody in the Wayne County Jail. Do you remember the date or how long you were in Wayne County?
I was in there 45 days.
How did she come back into custody?
I was in a car. I was in a car with someone and they was driving a stolen vehicle.
So you didn't turn yourself in, even after all that time. Motion for bond reduction denied. Bond will continue.
I didn't, honestly, it was all that time went past. I honestly forgot, Your Honor, about this charge. I would come. I don't mind coming to court for it. That's why I'm pleading guilty for it.
Take it up with Judge Washington. My decision is bond denied.
Thank you.
Why would why would you sit there and have me plead guilty to this?
You still gonna get the.
I got all these other court dates. My baby birthday is on the 20th. Why would you tell me I was getting out of here?
We're getting out. I told you the judge has to make that decision.
Oh, I'm sorry, guys. My baby about to be 2 years old and you playing with me like that, bro. Keep playing on the phone. Come out of here, bro. You don't let my family leave away. No. I'm about to miss my baby birthday, please. Bro, don't touch me. Don't touch me.
And it's gone.
Clerk, calls the case.
Where are we on this one? She said she was moving by the 31st.
I've been moving, Your Honor, but I've been doing this all by myself.
Now the courtroom shifts completely from criminal court tension into pure eviction court frustration. And this is the kind of hearing where emotions explode because people feel trapped financially. You can already hear the exhaustion in her voice. She's trying to explain that she's overwhelmed, moving by herself, juggling work, and still being dragged into court while trying to vacate the apartment. But here's the legal reality she's running into. The court mainly cares about possession, unpaid rent, and whether lease obligations were fulfilled on time. Emotional hardship may explain the situation, but it doesn't erase contractual responsibility. That's the brutal disconnect happening here. The defendant wants understanding, while the court wants compliance and timelines. And the more frustrated she becomes, the harder it gets for her to communicate clearly. Meanwhile, Judge Simpson is trying to separate emotional complaints from actual legal defenses. This is one of those hearings where both sides feel wronged at the exact same time, and that usually leads to tension escalating fast.
So I was intending to have keys back to them on Wednesday, which is the last day of my lease. That unfortunately did not happen. I was there all last night till like 2 o'clock this morning, moving stuff. I got back up this morning, called off work, and I've been there all day. I got a rather rude call from the apartment complex this morning, asking me about the keys, making threats to me, telling me she'd been in my apartment and asking if I had, intended to leave it in that condition. And I said, well, I didn't give you keys. I'm still in the process of moving out. You didn't have permission to come in my apartment. So like, she's now telling me she's gonna charge me another whole month's rent. And I literally left there with a load of stuff in my car to come here for this hearing. I don't even understand. I mean, I'm kind of like frustrated that they dragged me into court because they're the ones that said they weren't.
Well, ma'am,
I know I owe them. I applied for an SER and they denied me.
okay,
Like,
but
they are not reading my lease.
ma'am, you had said that you were going to move by the 31st.
Yes.
Okay.
And I've been doing everything I can to do so. I'm down to like probably 2 carloads of things. I've been moving stuff with my car all week long. I tried to contact the attorney to be like, look, like I don't have time to be in court because I'm taking off of work to do this. I'm trying to get moved. And they just were like, go to court. Every time that I've communicated with them, they either don't respond to me or they, just are rude.
This exchange is becoming increasingly emotional because the defendant feels ignored, cornered, and financially crushed, while the judge is trying to keep the discussion anchored strictly to facts. Notice how quickly Judge Simpson shuts down the implication that his office behaved improperly. That's important because courtroom credibility matters enormously. Once a judge feels someone is exaggerating or redirecting blame emotionally, the conversation tightens up immediately. But at the same time, you can tell this woman is genuinely overwhelmed. She's talking about moving carload after carload by herself, taking off work, scrambling to avoid extra rent, and trying to negotiate while under pressure. The issue is that none of that automatically stops an eviction judgment from moving forward. Courts deal with deadlines, not intentions. And this is where many tenants emotionally crash into the legal system, because trying your best and legally complying are not always treated the same way. The tension here feels especially intense, because both parties think they're being reasonable, but the law doesn't always reward emotional fairness.
You're not telling me my office is rude, because I know that's not true.
I contacted them and I said, look, please don't make me have to go to court. Like, I'm turning keys in at the end of my lease, like you guys asked to. And she just said, show up in court. And
Here's what I'm gonna do. I'm not gonna, how much is owing through? Well, there was
Now it's
2737 through.
3675, including 237 in cost.
How much?
Actually, 3675 plus 237 for 3912. That does include February, because it is February.
Right, and it would be due and owing. I'm gonna find after hearing, but there's no,
the days that I have had the keys.
did they leave? Yeah.
Yes.
Where's the judgment?
I have.
Did you sign it?
Yeah.
I need to look at it before you sign that thing. Stop them before you do that. I'm going to find no tribal issue. I'm going to grant judgment for possession to the plaintiff, as well as a money judgment in the amount of 3912. Money judgment was requested. That's going to be retroactive back to the date where a plaintiff did not ask for a judgment because you were moving by the 31st. So that's going to take 5 days off of it. You're almost out of the premises. So a writ would issue the 5th or the 6th, excuse me, of February. Thank you.
Sir, I applied for an SER and they denied me, and I didn't even try to bring
They're
that
not
up.
going to, but sir, but ma'am, they're not going to pay if you're no longer in the unit.
At the time I applied, I was still there, and they told me that they would not take my summons. That I don't know why he told me that my summons was not an eviction.
At this point, you can hear desperation fully taking over the conversation. She's no longer arguing that she owes nothing, now she's trying to reduce the financial damage before the judgment becomes permanent. That's a huge difference. Judge Simpson is also making something very clear here. Assistance programs like SERA aren't magic solutions after possession issues, and unpaid balances have already escalated. Timing matters. Documentation matters. And whether someone still occupies the property matters too. The defendant keeps circling back emotionally because she feels abandoned by the landlord and trapped by circumstances. But the court keeps returning to the same core issue: rent became legally due. That's why the judge repeatedly pushes her toward negotiating a payment plan instead of continuing the argument in circles. Honestly, this hearing becomes a perfect example of how quickly financial hardship can spiral into legal consequences that feel impossible to escape. Have any of you ever seen a case where both sides clearly struggled to communicate but still ended up locked in a legal fight anyway?
And that they denied me because the summons was.
Okay, but if they took it now, what do you think is going to happen? SER is not going to pay this amount.
I know, I understand that I owe them, but I'm trying to keep it down as much as I can because I cannot afford to pay this.
Okay.
I mean, I can't afford to pay the whole February. I did not pay them December and January because I had to use that money to move because they were supposed to renew my lease.
And here's what you do. I've given you to the 6th to get out of the premises.
I'm trying to have keys there today at 5.
If you're going to talk, then I'm not going.
I'm sorry.
I've given you to the 6th to get out now that you haven't moved. What I'm going to suggest regarding the monetary portion is that you contact the landlord or Mr. Friedman and arrange a payment plan for that amount. That's the best way to handle this. Okay? SER, Hawk, anybody else, they're not going to pay this. So you arrange a payment plan. I've given you a little bit more time to get yourself out of there, turn in the keys, and you're going to be good.
So then am I gonna have to pay the whole month of February? If
I've included the amount of February in here. You can talk to them about that. February is due. Okay? That's the way it works. Thank you.
We enter into payment plans all the time.
That's right.
So is that also gonna show up on a judgment on my,
Ma'am, yes, it is. Don't wave me like that.
I'm trying to work with them and they were not willing to work with me. I called them to ask them to not cancel my lease and they didn't even return my phone calls. Like I got bad landlord verifications from them, so I couldn't kind of.
Judge Simpson is trying very hard here to balance empathy with legal fairness, and that's not easy when both parties feel damaged by the situation. Notice how he reminds her that she already received leniency earlier when the court delayed judgment to give her time to move. That's important because from the judge's perspective, he already attempted to help stabilize the situation before it escalated further. But now, February rent is due, possession still hasn't fully transferred back, and legally, the landlord also has rights the court must protect. What makes this hearing compelling is that the defendant isn't acting defiant, she's acting emotionally exhausted. She's trying to survive financially while the legal system keeps moving forward, regardless of her stress level. And the judge understands that, but he also can't rewrite lease obligations because someone is struggling. This is one of those brutally human courtroom moments where nobody leaves happy, even though the judge is actually trying to create a workable outcome.
Yeah, that's a part.
Sorry. Like,
Ma'am, I understand the frustration. That's why you didn't get a judgment the last time you were here.
yeah.
I gave you to the 31st. You said you were going to move. I realize the circumstance that you're in now, but I have to also be fair to the landlord.
I
And
know I'm gonna owe them the money, but every amount that you put on here is just putting me deeper into.
what do you want me to do?
I would like to not have to pay the entire month of
Then talk.
February. I would like to have the keys turned in by 5:30 today, which I have enough time to do.
Ma'am, if you turn in the keys, then you have a good argument to talk to them about not having to pay February. The problem is right now, you still have possession of those premises. Your February rent became due yesterday.
And I have a 3-day grace to pay it, which is tomorrow.
Ma'am, I don't know what you're asking in terms of that.
Nothing. I'm sorry. I don't know what I'm asking. Thank you.
Thank you. Court does call the case of the people versus Jeffrey Bloom.
On behalf of the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, approaching the podium.
Good morning, Your Honor. Good morning.
We're here for a competency hearing, Your Honor. We've received a copy of the report.
You did?
Doesn't look like the court has.
I have not.
I could forward it to your staff if you'd like.
Okay. Do you have a copy with you or? Yeah. What does it indicate? I can give them mine.
It indicates that Mr. Bloom is competent, and I would be stipulating to the report.
I do need a report. I do need a copy of it because I have to review it before making a finding.
Okay.
Now we move into an entirely different kind of courtroom tension, competency proceedings, and discovery disputes. Judge Simpson immediately slows things down here because competency findings are serious legal determinations. The court cannot simply rubber stamp a psychological evaluation without reviewing the actual report. That's why the judge insists on seeing documentation before making formal findings. But then the hearing takes another turn when the defense starts discussing missing discovery materials, body cam footage, and correctional officer reports that allegedly were never provided. And that's where things become dangerous for the prosecution side procedurally. Discovery problems can delay cases, create appeals, and raise fairness concerns if evidence isn't fully disclosed. Meanwhile, the defendant clearly feels ignored and increasingly distrustful of the system itself. You can already sense this is about to become less about one isolated criminal case and more about broader accusations involving jail treatment, medical care, and institutional misconduct. The courtroom atmosphere shifts from frustration to outright instability, incredibly fast here.
Presuming that is going to be the finding, and I'll wait so I can at least review it. What are we going to do on this case?
Right now, Your Honor, we're going to be asking for an adjournment of 2 weeks. There are certain discovery requests. We've reviewed the police report. It's that there are copies of reports from 5 or 6 different correctional officers that were not attached to the police report, as well as a written statement from the main complainant, which states that it's been attached, but it hasn't been attached. And we're also going to be asking for body cam videos from Sergeant Craig that states would be part of the discovery, but we don't have that yet, Your Honor. So I think 2 weeks should be enough time for us to get those. I'll send an email to Ms. Barroso later today specifying that, Your Honor. So we're going to be asking for an adjournment to make that happen.
Can I speak?
Well, I'll ask the court first, but yeah. And Mr. Bloom would like to make a statement to the court as well, Your Honor.
This never goes well.
Good morning. Good morning. Your Honor, do you remember you blatantly ordered the public defender's office to give me these copies of these officers' reports and look how long it's been and they still.
I don't know whether or not, I don't have a note that I did that. I don't recall that.
Okay, well, it's been since October and they've failed to provide any of this information. Your Honor, if I might put something on the record regarding this case, not to deal with the case, but to deal with me having very little sleep due to a highly painful tooth that I'm being refused care for by the WellPath dentist, same staff who are falsely accusing me of battery on Rocky, a WellPath nurse. I've written multiple kites on 1 page, no paper trail kites. There's no proof that I've even written a kite.
This statement is intense because the defendant is no longer simply discussing his criminal case. He's launching into a much bigger narrative involving medical neglect, mistreatment, denied medication, and alleged abuse inside the jail system. Whether those claims are true or not, the emotional urgency behind them is obvious. He sounds exhausted, paranoid, angry, and desperate to finally be heard publicly. But notice Judge Simpson's posture throughout this entire stretch. The judge mostly allows him to speak without fully engaging the accusations directly. That's strategic. Courts often avoid litigating unrelated jail complaints during active criminal proceedings unless formal motions or evidence are presented correctly. Still, from a viewer perspective, this becomes incredibly gripping because the defendant clearly believes the system itself has turned against him. The references to denied pain medication, destroyed evidence, manipulated phone access, and alleged retaliation create an atmosphere that feels chaotic and deeply uncomfortable. And honestly, moments like this remind you how quickly courtroom proceedings can shift from legal arguments into raw human breakdowns.
So I've gotten no response, but I've had a Midnight Sergeant Christopher D come tell me that I'm being denied dental treatment because of, get this, security issues. These same people who have falsely accused me of injuring them have even denied me Tylenol or Motrin for several days in a row, and all correction staff are indifferent to any requests for help. And the lieutenant over healthcare, Lieutenant Thomas Arnett, whose staff say he and Cindy DeVue are an item, well, he has even gone as far as to manipulate my phone and spread a blatant lie stating no one wants to have contact with me. My mother, father, no one. I've proven this to be a lie, Your Honor, but he is also over the phone system. So yeah, he refuses to answer as to who in fact has told him they want no contact. I've been denied even basic human necessities for over a year, Your Honor, and several COs have told me they don't understand it and will testify for me in court. But Lieutenant Arnett, along with his people, will use any means to justify their malevolent actions, saying, I don't accept responsibility for my actions and behaviors. Even when I'm denied Tylenol for days with excruciating dental pain, WellPath has stopped me from taking Parkinson's meds and other meds because they've tried to give me the wrong meds 5 times, Your Honor, in the past year. 2 sergeants threw away this evidence, and Sergeant Cena Justice even had a major misconduct written on me because all I wanted from her was documentation that this happened. Okay, I've got an officer that will testify to that also. I have evidence to support to all I claim, Your Honor. If someone is seeing this, a civil attorney or anyone who can help me, please be sure to contact me and not be deceived or manipulated by jail staff or WellPath. Thank you, Your Honor.
Thank you. I received the report, and the parties are stipulating to the report. And based upon that report, the court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Mr. President, I need an order sent to the court for my signature.
Yes, Your Honor.
And then we'll adjourn this matter out to February 21st, 2024 at 9 a.m. And hopefully we'll have all of the information that's requested at that time. All right.
Thank you, Your Honor.
Thank you.
So much.
This is a horrible day.
And just like that, Judge Simpson brings the courtroom back under procedural control. After all the emotional allegations, frustration, interruptions, and escalating tension, the judge returns to the one thing courts rely on most: formal legal findings. The defendant is officially ruled competent to stand trial, meaning the court believes he understands the proceedings and can rationally assist in his defense. That ruling is critical because competency questions can completely pause criminal cases if someone is deemed unable to participate meaningfully. But here, despite the defendant's lengthy and emotional statements, the court ultimately decides the case can continue forward. Across all 3 hearings today, one theme stayed consistent: emotion may explain behavior, but it does not automatically override legal responsibility. Whether it was missed court appearances, eviction disputes, or allegations involving jail treatment, Judge Simpson consistently focused on procedure, timelines, and accountability while still allowing defendants space to speak. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.